Hello and welcome to Webinar Wednesday. Today we have with us Steve Perry from Kasner and Edwards. Steve will be going over independent contractor status and the best practices for real estate brokers. Just a reminder to everyone, the webinar will be recorded. Steve's slides will be available after the fact, and if you have any questions, please ask them when they come up and we will go over them at the end of the webinar. If there are any questions after the webinar is recorded, you can contact MAR and we will get you those answers. Now I'd like to turn it over to Steve.
Thank you. Good morning. Sorry for the delay in getting started today. We had some technical difficulties with the PowerPoint. But we'll be talking today about independent contractor issues for real estate brokers. And what I'm going to do is first review the Monell versus Boston Pads case that many of you are familiar with, and as well as a follow-up case that took place against the same company and which will tell us that we may want to consider using arbitration agreements. We'll also be talking about best practices for brokers to minimize the risk of employment claims, both at a federal and a state level. And I also want to give a heads up to the way in which the new statute as part of the grand bargain, the paid leave law, may have an impact on real estate brokerage firms, although it's not anything that people will need to do something about right now, but there ought to be a heads up. So I'm going to start with the Monell case, which I personally handled along with Bob Kuttner. And in that case, the defendants were in the business of residential rentals through Boston Pads, and they were paying their agents on a 1099 basis, which is, of course, common in the industry. And several of their agents, including one of their managers, brought a class action claiming that the agents should have been classified as employees. And they made three kinds of claims. They were claiming that as employees, they should have been paid on a minimum wage basis, whereas they were in fact being paid on a commission basis. So therefore not always being paid every week for the hours they were doing. They claim that they should have been entitled to overtime, time and a half times the minimum wage for all hours that they were working beyond 40. And of course, nobody was keeping track of those hours. And they also made claims that certain deductions that were taken from their commissions by agreement in the nature of things like desk fees, where they might pay $50 or $75 a month off their commissions, that those were illegal deductions for an employee. And all of this they were seeking to have trebled. So it was an amount that if they were to recover all of it plus attorney's fees, we were talking about ruinous liabilities under state law. In addition, there were some facts that were being alleged that were difficult for the defendants because, again, this was a residential rental business, so they had less experienced agents. They had many of them. Unfortunately, there were policies put in place that referred to the agents incorrectly as employees rather than independent contractors. There was arguably, according to the plaintiffs, more control being exercised over how the agents conducted themselves than might be necessary to assure their legal compliance with real estate brokerage laws. There were facts that they ballyhooed that could be distorted, such as allegations that the agents had to take out the trash, which really just meant that if agents were in the office, the last one at the end of the day was expected to clean up after themselves and put a bag out. But the way this looked in the court papers was a little bit damaging. And we also had a manager who was effectively acting as a double agent, an individual who was writing some of the policies they were complaining about at the very same time that we allege he was meeting with plaintiff's counsel and plotting this class action. So there were some difficult facts to overcome. Plaintiffs put all of their eggs in one basket. They relied on the theory that the independent contractor statute in Massachusetts made these individuals employees. And that statute has a three-pronged test for independent contractor status, which you will see is impossible for realtors to meet. it required that the agents be free from control and that the services be outside the scope of the business of the firm that engaged the agents, and it required that the agents be effectively hanging their own hat, which usually means that you can work for other people. And under state law, unless all three of those prongs are met, the Wage Act would define an individual as an employee. Now, as you know, the real estate licensing laws go in a different direction from that. They require a significant amount of control over the agents to ensure compliance with law and to protect the public. So that raises problems under the first prong. The second prong of that test, which was that the services be outside the scope of the business, is completely inconsistent with what is required under the licensing laws, where all of the agents' transactions must be part of the broker's business and in fact concluded by and supervised by the broker. So that prong is impossible for a real estate agent to meet. And the third prong is problematic as well because under state law, the agents are required to affiliate themselves with just one broker and can't work for more than one, and that is preventing them from hanging their own hat. So when we looked at this on behalf of the client, we knew that there was no way that this firm, or probably any brokerage firm, could meet the three-prong test in the wage statute. And our argument was that if you applied this three-prong test to the Boston Pad defendants and applied it, it would have to apply to every other broker in Massachusetts, and everybody would be an employee and would be misclassified. You wouldn't have any independent contractor status for agents. And yet that would be in conflict with the licensing law, because the licensing law says that you may affiliate with your agents as either an independent contractor or an employee. We argued this in the Superior Court, the lower court, and we won. The court dismissed the claims that were based on the three-prong test, and the court said you can go ahead, plaintiffs, and try to prevail on some other theory that you're employees. They could have, for example, argued that Boston Pads was exercising too much control over their brokers and that should make them employees without regard to the three-prong test. However, the plaintiffs again took a risky approach. They didn't want to continue the lower court case and have to litigate those issues, which were a little harder to litigate on a class basis. So they agreed that they would dismiss the appeal, they would dismiss the remainder of their case in the Superior Court, these other theories that they might have, and go up on appeal just on the one issue of whether the three-prong test applied, and if they were wrong about that, then they would lose. And we were agreeable to that because we thought there was a good chance we could win on that one issue, and it avoided the necessity of litigating these other possibly problematic claims. So the case was appealed. The Supreme Judicial Court agreed to take it. We argued it to that court, and the court held in our favor that the three-prong test of the independent contractor statute is not the test for real estate licensees because that would be inconsistent with the real estate licensing laws. And the court also ducked the issue of whether people such as the agents in Boston Pads were employees, saying that they would leave to another day the issue of what the right test is to apply for whether you're an employee or a contractor. They said it simply isn't the three-prong test in the independent contractor statute. However, the Monell plaintiffs weren't in a position to raise this issue because they had explicitly waived it and agreed that if they lost on appeal, we would win final judgment. So we consider this to be a huge win for the industry, not only because the three-prong test is not applicable to real estate agents, but also because what Monell tells us is that if you do things that are required under the licensing laws, such as exercising supervision and control that assures ethical and lawful behavior, or that is necessary to comply with a statute, that is not going to be enough to cause agents to be employees. It's going to have to be more than what the licensing laws make you do. Now, as I mentioned, they had agreed in the Monell case to that we were entitled to a final judgment if they lost the appeal. and they lost the appeal. But before the ink was even dry on that decision, the plaintiffs went back to Superior Court and tried to relitigate the case and to have to amend their complaint and to pursue the theories that they had waived. Fortunately, the Superior Court rejected these efforts and upheld the judgment that plaintiffs' counsel had agreed to. But that wasn't the end of it. A few months later, the plaintiffs' counsel found another individual who had worked for Boston Pads named LaToya Patterson and tried to file a new class action case alleging theories that had been left open in Monell. And she claimed that she had worked for Boston Pads for about a year back in, I think, 2010. Our records indicated she had only worked there for a month or two and that she had left after she failed her real estate license exam. She never made a sale or received a commission, so we didn't think she was really a viable plaintiff, but if with a class action, there was a risk that she could act on behalf of others or that they could amend the complaint and add others. And this is where the arbitration issue comes in. We determined that this individual had signed an agreement agreeing to arbitrate any employment claims and not to bring a class action in arbitration. So we moved to dismiss on that basis. And the Superior Court ruled in our favor, despite an argument that was made that this kind of waiver of a class action is a violation of federal labor laws, which was a very hot issue at the time. In fact, it was an issue that was being litigated up to the Supreme Court. So after we won in Superior Court, we agreed with the other side that we would put our case on hold until the Supreme Court could issue its decision about whether you could be forced as an employee to arbitrate on a non-class basis. And that case, after Justice Gorsuch was appointed and confirmed, came out in May of this year, May 21, 2018. The Supreme Court of the United States held that agreements by an employee to arbitrate and not to bring a class action is not in violation of federal labor law. That resulted in our case being alive again, but not as a class action. The Patterson case, she was going to have to arbitrate. Her attorneys came to us and wanted to settle, and they wanted $30,000 just for her claim. We argued that she actually had no valid claims. She had only been there for a few weeks and had never made a sale, and we were able to settle the case for the grand total of $640 without any confidentiality agreement. And finally, the saga is over for that client. So where does all of that history leave us? Under federal law, federal tax law, in order to classify an individual as an independent contractor, the agent must be licensed. There must be a written agreement that says the agent is not an employee for state and federal tax purposes. And substantially all of the agent's compensation must be based on the agent's output, which in this context really means you're paying the agent on a commission basis rather than some kind of fixed stipend. And if you meet those three requirements, now you're an independent contractor for purposes of state and federal tax law. With respect to unemployment compensation and workers' compensation in Massachusetts, there are state exemptions that apply if the agent's paid on a commission-only basis. Those shouldn't be an issue at all if you have the same written contract and pay the agent on a commission basis. Under state law, state wage law, Monell left the issue open of whether somebody might be considered an employee rather than an independent contractor. But as I said earlier, they said it's lawful to have independent contractors. And they've also indicated in the holding of Monell, at least the logic of it, that if the broker is exercising control and taking actions that are required by the licensing laws, that is not going to be enough to turn the agent into an employee rather than an independent contractor. On the other hand, if there's control exerted over the agents that in ways that are not necessary to protect the public or to carry out the licensing law provisions, then that might increase the risk of a misclassification claim under the state wage laws. We'll come back to that later as far as some best practices. Federal law is different. The Monell case has no bearing on federal law. And the definition of employment under the Federal Labor Standards Act is broad enough that it could potentially pick up some real estate agents. The best protection under federal law is not to assume it doesn't apply, but to make sure that the agents are exempt from minimum wage and overtime under the Federal Labor Standards Act as, quote, outside salespersons, unquote. And to be an outside salesperson, the agents must be principally involved in outside sales, which would include the sale of real estate. They must regularly and customarily have occasion to work away from either their home or the firm's office. Their home counts as an office. So they have to be out on the road, out in the field sometimes, which you would normally be if you were taking listings or showing houses. And if you have agents who are conducting themselves in the normal way, taking listings, showing houses, being paid on a commission, they should be outside salespeople, exempt from the federal wage laws. Another issue one might consider is, are the agents covered by state and federal discrimination laws, because those have yet another definition of employment. And there's a strong public policy in protecting individuals who might look a lot like employees, even if they're classified under state law as independent contractors. So I would say that the agent's status as employees versus contractors under this non-discrimination laws is unclear, might be decided on a case-by-case basis. Public policy supports their having rights. There's also some state statutes that could apply even if they're not employees. And I would recommend that offices have properly worded policies against sexual harassment in the workplace and against harassment based on other unlawful categories. And simply word it to say that these policies apply to sales agents and associates rather than referring to them as employees, but have the same kind of protections that you would if they were employees. Ensure that people who experience harassment based on their gender or sex or nationality are protected and can bring a complaint, and it will be investigated and addressed just as you would do if they were employees. So to summarize some of the best practices do's, it would be have a written agreement. And one possibility is to take a look at the Mass Association of Realtor Model Agreement. And your agreement should specify independent contractor status, state that the agent is not an employee for state and federal tax purposes. It should classify the individual as an outside salesperson, and you'll want to make sure that the individual, in fact, has the principal responsibility of making sales and is customarily and regularly outside of the office. That doesn't mean they can't work in the office half the time. It just means that they regularly leave the office to go and engage in sales activity once a week or whatever. They're not simply doing all their business in the office, never leaving because somebody else is doing that for them. And we also would suggest that you consider having an arbitration clause where the agent must submit disputes with the broker that arise out of the relationship to some form of binding arbitration on a non-class basis. And you specify the arbitration tribunal. The two big ones in Massachusetts are the American Arbitration Association, or there's an organization called JAMS. And either one would be experienced in administering arbitrations. As we touched on earlier, another best practice, important for a lot of reasons, is that the agents be paid on a commission-only basis, not being paid a salary or stipends if you want them to be exempt. This is necessary both for federal and state tax purposes and to fit into the exemptions from the workers' compensation and unemployment compensation laws. So if you were to have a substantial amount of compensation that was for other things like attending meetings or anything else, or doing other kinds of work, that could theoretically at least create issues as to classification. You want to avoid, and these are the don'ts, avoid exercising control on the agents that goes beyond that which is necessary to comply with the law and assure that they're acting ethically, lawfully, protecting the public. So the kinds of things you might be concerned with as going too far would be written dress codes, maybe written sales scripts, things like quotas on how many calls or contacts or mailings have to be made, policies that might require somebody to work particular hours or to work particular office hours. All of those kinds of things might tend to lead in the wrong direction as to whether they're employees or contractors, and if you had enough of them, that might tip the balance. And of course, you don't want to call them employees in any of your written policies. Now, a special issue that I think could create problems for some companies are the way in which broker teams are organized. If you had a team of brokers and all of them were regularly engaged in outside sales and simply covered for each other, that's probably not a problem. But if you had a team where some of the individuals were doing all of the outside sales work and others just sat in the office and were responsible for paperwork, or maybe they went out and did photos and videos, but they weren't doing the sales activity, those individuals might not meet the outside salesperson test and might look like employees and create a host of issues, such as who is the employer, is it the other agent or the firm? And of course, you have licensing constraints on who can pay the affiliated brokers and how the commissions flow. So I think if you have broker teams where people are not actually engaged in outside sales, that's a problem you've got to look at, and it's something that probably needs to be discussed with counsel. It's complicated. And the risk there would be that the individuals who do not get outside of the office might be entitled to minimum wage for all the hours they work, even though they're making a healthy living on commissions as part of the team. There's ways to solve it, perhaps, such as guaranteed draws, but they may have to be treated as W-2 employees. And the last thing I wanted to touch upon is what happened a few months ago with the grand bargain and the paid leave law. The paid leave law was passed at the very end of the session, and it has a current effective date as of January 1, 2019, although I think that's only the date when some of the contributions are supposed to start. And the way this law was written, and perhaps because of a desire to target industries such as cab drivers, the law applies both to employees and independent contractors. And there's some ambiguity in the statute, but there's an indication that the expectation is that there might be contributions required from the brokerage firms, which would be in the nature of a payroll tax on commission payments to independent contractors. Now, the statute has almost diametrically conflicting provisions on that. One says that that if somebody wants to participate as an independent contractor in the system, they have to pay their own freight. There's another provision that reads as though the entity that's engaging the contractor must pay a portion of it, and it's unclear which of those will apply. The Massachusetts Association of Realtors is pursuing the issue, trying to get clarification as to its coverage, and also exploring solutions if this were in fact going to be applied to brokerage firms. Now, the brokerage firms, if this applied, wouldn't have to be administering or adjudicating leave requests. That would be done under this statute by a state agency. The real issue is that there might be a payroll tax. There's no action required right now on this. I just wanted to give you a heads up. So this is something on which you should stay tuned. That concludes the prepared portion of my comments, but I would be very happy to answer any questions that people have.
Thank you very much, Steve. We do have a couple questions. The first question is, For whenever appropriate, since the Monell decision appears to ask for someone to bring a, quote, facts and circumstances case, what happens when someone does?
Well, in order for somebody to bring a case, they would first file a complaint. If it's a wage case under state law, they would typically file a claim with the Attorney General's office, which typically wouldn't have any interest in investigating it, and in most cases would be inclined to have the individual pursue his own rights, although there's no guarantees on that. So let's suppose somebody files a claim with the Attorney General's office and gets a right to sue letter. Now they could bring a case. So the first question again is, does this person have an arbitration agreement? Because if they do, now you're dealing with an individual case and not a potential class action, and it would be arbitrated. Otherwise, if you don't have that, it could be brought in court, and either way, you're looking at a potential triple damage claim. As far as the facts and circumstances, I would anticipate that the individual would have to show that the practices engaged in by the brokerage firm went significantly further than what is typical in the industry for supervising agents as required by state law. So the type of supervision that requires that you look at their contracts, that you have policies for getting all of the paperwork right and doing all the disclosures, those things aren't going to get you in trouble. But if you are requiring people to show up at the office 40 hours a week or that kind of thing, that might be a different situation. So the facts and circumstances would be determined in the context of litigation, but the plaintiff would probably have to show after Monell that there were facts and circumstances that went much further than what is required or contemplated under the licensing laws that say you can be an independent contractor subject to the broker's control.
Oh, never mind. Go back then. Sorry. Okay, thank you very much. What about excessive control? What will that do?
Well, if you had excessive control, then under state law, one could argue that the individual was an employee, not a contractor. Now, the implications of that might not be as dire as they seem, because you would still clearly be a contractor for state and federal tax purposes. Control has nothing to do with whether you're an independent contractor for state and federal tax purposes because of that safe harbor provision we talked about, where if you have a written agreement, they're licensed, you pay them on a commission basis, and it says they're independent contractors who might have taxed that way. That's conclusive. So you'd be looking at a potential wage claim, but not a claim about withholdings. And on the wage claim side, if they were commissioned salespeople, you would still have the argument under federal law, they'd be exempt from the Federal Labor Standards Act for reasons I said. And under state law, you'd have arguments that they're also exempt from overtime and minimum wage under exemptions that apply there. You'd be looking at potential exposure if you had the kind of desk fees or other deductions that were being made in the Boston Pads case. And there's also an issue under state law potentially as to whether it's okay not to reimburse the expenses an agent incurs if they're employees. Although if you have deductions or that kind of thing from a commission policy, that's also lawful under state law. These were all defenses we planned to assert in Monell if we had lost on the three-pronged test issue. So it's really not a disaster necessarily. If you have too much control and they're classified as employees, the next question would be, okay, what kinds of claims do they actually have if they're outside salespeople paid on a commission-only basis? And it's not clear what those claims might be, but you might be looking at claims for unreimbursed expenses or for any kind of deductions from pay that aren't part of the commission policy.
Can a part-time employee who is on payroll also sell real estate as an independent contractor?
Okay, so now we're talking about somebody who works in the office. If the person is being paid as a W-2 employee for part of their work, and you now want to classify them as an independent contractor, I think you have a problem under the federal, I think you have problems under a host of federal and state laws in trying to make them an independent contractor on their commission side. That is because the individual's compensation is not going to be entirely based on their productivity. There'll be a disputed issue as to whether their primary responsibility is outside sales. So the safest way to do that would be probably to classify them as an employee and to provide extra compensation for any real estate sales. And you'd have to look at whether they are exempt from overtime, but they might very well be bona fide administrative, or it might be if they're part-time that they're not working over 40 hours even with the real estate sales. But I think that is a problematic situation that would have to be addressed.
Would providing calling cards and or postage generally to agents be problematic?
Reimbursing agents for postage is not, reimbursing expenses is not going to be viewed as compensation. So that was one part of the question was, I think, paying postage. And the other part was travel cards. I think that you would need to be careful when you do these things that you're acting within the scope of reimbursement of actual expenses. If you're providing these kinds of perks and there's no accounting for how much the agent is actually spending and they're making money on it, now it looks a little bit like when the NBA refs were getting paid not to take first class flights and ended up in jail. You got to be careful with sort of unreported income around that. If it's all just expense reimbursement, it's not going to mess you up. If it's beyond expense reimbursements and people are actually making money on it, then it raises a bunch of issues.
All right, the next question is on teams. If the transaction coordinator is payroll but receives a bonus on each sale of the team, does that bonus have to go through payroll or can it be given with a 1099?
That bonus probably ought to be treated. I'm answering these obviously without giving a lot of thought to them, but I believe that sounds to me like you'd probably have to run the whole thing as compensation. Once you have an individual who's being paid as an employee for part of their work, it's doubtful that you can now treat another part of it as 1099 income.
Okay. Can an agent broker be working or affiliated with more than one office?
The licensing laws do not allow that.
If a brokerage has agents who have not previously signed independent contractor agreements, is there any issue with compelling them to execute such agreement to ensure continued affiliation?
You really, if you have agents who have not already signed an independent contractor agreement, yet you've been paying them as independent contractors, that's an issue. And you can't lawfully treat them, probably cannot lawfully treat them as independent contractors going forward. I'll take that back. Whether they would actually be independent contractors under federal law would now be a facts and circumstances test because you don't have the agreement. However, you could certainly say to your agents that in order to continue the affiliation, we need all our agents to sign an independent contractor agreement. And if they didn't want to sign it, I don't think that would create any rights on their part. Of course, I don't know what would be in your agreement, whether there's anything oppressive in there, but generally speaking, you could say we need you to sign this agreement to continue with us.
I find that our agents perform better when in the office and have management immediately available to them for coaching and mentoring. How can we require office hours without exposing ourselves to a legitimate claim against us?
Well, I think that when you do require office hours, you've increased the risk that somebody will say that's an unnecessary control and that the individual's been misclassified. Now, again, you have, if they're still getting out and if their primary duty is outside sales, yet they're required to spend a lot of time in the office, you still probably have an exemption under federal law, and you still probably have an exemption under the state overtime law. The state has a very funny minimum wage law that talks about not requiring people to go to the office every day as part of the exemption, so you could have a problem. But we also did amend the licensing laws with the help of the Mass Association of Realtors to say that you could pay independent, that it's lawful to pay commission-only agents. It's lawful to pay independent contractors who are outside salespeople on a commission-only basis. So maybe it's a situation where you decide to do it and you take the risk because you're not sure what category of damages these people would be entitled to if they were in fact misclassified. But you're just increasing the risk that somebody could make a claim.
Can you clarify the last question about an agent being compensated for more than one office? What about if they're from different states?
I don't know the answer to that.
As brokerages roll out new technology and CRM tools, encouraging agents to adopt them, does this present any issues?
I guess I'm not really sure of what kind of issues that the questioner is referring to. I doubt it. These are tools that would be the agent can utilize for the office. I suppose that claims can be made that too much control is being exercised. But I do want to go back to what I said earlier, which is at any time you're worrying about too much control, you also have practices do we have that might cause this alleged misclassification to actually lead to a damage claim. If we're paying everybody on a commission basis, if they're all exempt from overtime under state and federal law, if they're all exempt from minimum wage, you might conclude that some of these extra controls aren't going to expose you to very much.
Cool. Well, thank you very much, Steve, for being here. Just want to remind everyone again that this has been recorded and it will be up on the MAR website shortly, along with the slides. Thank you, everyone, for joining, and have a nice day.